this event sponsored by the Center for Historical Research. It gives me great pleasure to welcome back to Ohio State Professor Aaron Retish. Aaron earned his PhD here in the history department, and I had the pleasure of being his dissertation advisor. He is now a associate professor at Wayne State University and has a very distinguished publication list. He's published an award-winning book called Russia's Peasants in Revolution and Civil War, published by Cambridge University Press in 2008. He's co-editor of another book, Russia's Homefront in War and Revolution, Volume 1, Russia's Revolution in Regional Perspective. He is also the co-editor of Revolutionary Russia, which is one of the leading journals in the field. He's published a large number of articles, too many to mention here. He also has a large number of awards and grants, also too numerous to mention in total, but let me mention a couple of those anyway. He's the winner of a Harry Frank Guggenheim Fellowship, American Philosophical Society Research Grant, also an Eisenberg Institute Research Grant, and he has won the Presidential Award for Excellence in Teaching at Wayne State University. His current book project is called In the Courts of Revolution, Vengeance, Loyalty, Legality, and Citizenship in the Rural Soviet Courtroom, 1917 to 39. And it's a draft chapter from that book that we'll be discussing today. So first, Aaron would like to make a short presentation, and he has some visuals as well, and then we'll open up the floor for questions and discussions about the draft chapter that he's presented. But first, please join me in welcoming Aaron Retish.
It's really my honor and a little bizarre to be here. I remember being on that side, so I almost feel like I should be turning in a dissertation chapter. But thank you very much for having me. It's really my pleasure to be at OSU and a pleasure to speak about my work. So this is, as David mentioned, the first chapter of a longer book project that looks at the local court system in the early Soviet period. And the book and part of this chapter looks at the people's courts. These were the courts of first review in the Soviet legal system. They were the most widely used courts. They were the foundational courts. They actually survived the Soviet system and continued into the 1990s. And it was in those courtrooms, I argue here, that the Soviet state asserted control, that it began to build socialist values. And it also was the place for peasants to turn to resolve claims that they could not resolve in the peasant huts and among themselves. It was also the place where the state prosecuted petty crimes, arson, hooliganism, etc. So that's the first half of the chapter. The second half looks at the other, and so that is a longer lasting institution of legal jurisprudence. The other half of the legal institution during the revolutionary period up to 1922 was the Revolutionary Tribunal. These were, while people's courts were courts of negotiation between citizen and the state, revolutionary tribunals were prosecutorial. That is, that the state brought action upon its citizens on counter-revolutionary crimes. And I argue in the chapter, and something I'm going to talk briefly about right now, is that these presented kind of paradoxical situations. These were revolutionary institutions, but they also worked to stabilize society. That they stabilized the revolution, that they actually protected citizens against violence, and they maintained order. Both the revolutionary tribunals and the people's courts. So my question then, for kind of the bigger question here, is how did they get to this, which is these were the courts before, the local courts in the countryside before the revolution. Township courts, the volus courts. These were based on customary law over by judges chosen first by the administration and then by the peasants. How did they go from that? That's from 1906 to this. This is from the early 1920s, and this is a people's court with the judge there in the center, who was chosen by the Soviets, local Soviet, the lay magistrates, you can see there, the woman on the left, as well as the man on the right. The secretary, you can see there on the far right as well. So how did they go from one to the other? And I argue that the transition wasn't actually that revolutionary. That it was 1917 was this key component. So the old argument was that, kind of one of the arguments is that the people's courts in the early Soviet period were essentially the continuation of these township courts. They were peasantized courts. But I argue that, in fact, they were something different. That in 1917, under the provisional government, they established these new court systems called the Justices of the Peace, and these were liberal institutions designed by the Zemstva, and this is a photo of one of the districts of the Justices of the Peace in one district in Vyatka. And what happens during the revolution is it's not these former judges from the township courts that take on the people's court judgeships. It's actually these people from 1917, from these new institutions, from these justices of the peace. These were democratized institutions. And from all of these, almost every single one of them became people's court judges, including this guy in the center, Nikolai Popov, who would actually become one of the leaders of the provincial people's court and actually become the head of the People's Court Soviet. So these were all from the provisional government, and they actually continued into the Soviet period. I have another image of them at the Congress. So if you look at the guy in the center, this is actually from 1921. You can see him in the center there as well. These are all the People's Court judges, a younger group than they were from before the revolution. And I have found that almost every single one of the People's Court judges and officials actually came from either 1917, that the judges came from 1917, and that the assistants, the secretaries, and the other clerks of office actually have served in the Tsarist administration from before the revolution. So there actually wasn't this radical transformation in the local court system. There wasn't actually this revolution. There was more of a transition. This is from 1922 from Murmansk in the north. That kind of shows this transition from Tsarist to Soviet. There's still the double-headed eagle on the right. They're actually citing Tsarist law, Tsarist legal codes, and they actually right here just cross off part of the Tsarist code. So the Soviet government abolished all courts in the winter of 1917, and they also abolished the civil and criminal legal code. So there actually were no standing laws, supposedly, at the end of 1917. However, if you read the archival records closely, so there you have this revolutionary aspect. If you read the articles clearly, what they say is that all the courts would be abolished except for the justices of the peace. That would actually remain, and that the new judges, before they came up with the new legal code, should abide by all legal codes that don't go against proletarian consciousness, whatever that meant. So that meant that local people's court judges continued to use and cite old legal code, even if they weren't actually on the books. Because they were using secretaries and other clerks from before the Revolution, they continued to use the old court procedure, including evidence and actually how the court was run. And you actually see this with the claims that are brought before the courts. Most of the claims brought before the courts were commercial claims that continued from before the Revolution. This is not to say that the Revolution, that the courts weren't that revolutionary. The majority of cases heard before the local people's courts were actually divorce cases. The Soviet government in December of 1917, in the first family code, legalized divorce. And so peasants rushed to the people's courts to end their unhappy marriages. They rushed to the courts to end spousal abuse or to try to get divorced so they can marry someone new. And this was the dominant civil claims that people's courts heard. So I've tried to argue in the book that it's this mix of both kind of stability and revolution. There was the stability in legal codes, stability in personnel, and yet the courts, the people's courts, were also engaging in trying to change social complexions, that is, social values at the local level. On the flip side, and kind of a more revolutionary institution is kind of the last part of the paper, and that's the revolutionary tribunals. Revolutionary tribunals, the judges, this is the provincial, this is Vyatka province, this is the provincial revolutionary court. This is the chair right here, Foifanov. And they were almost always Communist Party leaders. And they heard enormous number of cases in Vyatka province between 1918 and 1921. They heard over 5,000 cases. Most of these were based on speculation, espionage, counter-revolution, and they really were these courts that were supposed to foment revolution and also decide cases based on proletarian consciousness. And yet I also found, and to give you a couple of images of actually deciding cases. This is kind of this classic example of going into the countryside. It's an open air, so you see that the performative aspect of the Revolutionary Tribunal with the public surrounding them and the accused there in the center. The tribunals were quick, although the decisions often weren't as quick. And then here's actually another one from the exact different case, same locale, different perspective. But you see that they actually go through a number of cases in the same day. And then these cases would then be reported and kind of triumph in the local newspapers to kind of show it as education. I think I have one more. There we go. That's just actually the sentencing. And yet, I argue that even as they were revolutionary, they were also there to establish order and to provide stability. In 1918, a lot of the cases that the Revolutionary Tribunal held or heard were cases of economic speculation, and actually they were trying cases from before 1917, including prosecuting peasants from early 1917 for disrupting grain. And then later on, by 1920, 1921, the majority of cases that Revolutionary Tribunals heard were against official corruption. So again, they were trying to, and they were actually going against party officials who had gone, that were too vigilant in their attacks on citizens, or they were too vigilant in following orders. So they were also trying to control kind of social stability and the violence surrounding them. Even if you look at the case, the sentencing, these two in the Revolutionary Tribunals, that execution was actually rather rare. that most of the sentencing was, especially by 1921, was limited in scope. So I think I have one last image to give you a sense of the end. This is actually from 1929. Again, another people's court, and this was so this is after the Revolutionary era, but again gets at the idea of the performative aspect of the courtroom. So this is probably a show trial, not in the Stalinist sense of the show trial, but probably a case in which they were trying to get the public to educate the public. You can tell that because it's outside. This is actually the courtroom in there. So again, you have the judge, and then the two lay magistrates, and then the secretary as well. All of this, I argue, is that the Soviet state was trying to impose values upon its citizens, but also that in the courtrooms, in the people's courts especially, that peasants were able to continue a legal culture. That is, that they used the courts, they used them voluntarily, they used them collectively, and they used the courts with the thought that they would be able to resolve disputes. And that even though this was challenged by the violence and instability of the Civil War, that peasant legal culture actually continued. In my book, I argue that it actually continues all the way through 1939. So I'll end it like right there. Hopefully that's giving you enough food for thought. So if you've read the paper, I'd be happy to take questions about that. If you haven't read the paper, that's also fine. And I'd be happy to, I'm interested in comments and discussion. Thank you. Yeah.
So it's interesting because we're talking about a lot of the cases that are tried in these courts are divorce cases. Could you comment on any ideas you have about the gendered effects and kind of the gender dynamics of those cases?
Yeah. So in the pre-revolutionary courts, the majority of claimants before the township courts were women. And they were doing that because the courts provided a place that, after they'd gone through all the traditional paths, that the courts offered the place of last resort. And I found the same thing under the people's courts, that women during the revolution, especially in the 1920s, would go through the Soviets or the village institutions, but often would then turn to the courts to resolve spousal abuse, to resolve alimony, and then, especially in the early 1920s, this became a central part of the Soviet local court system. That it was, let me answer this in kind of two ways. That it was a place for allies of the Soviet state to be able to get new rights and of the welfare state. And it was something that peasant women understood, and they turned to the Soviet courts to get claims. This is clearly seen in child support and paternity. So they would actually, this would be given through propaganda and literature that the courts were places for them to actually be able to seek claims, and peasant women regularly turned to the courts, and the courts were more than willing to support women, especially on paternity. I can only remember a handful of cases in which women turned to the courts for claims for child support in which they were denied. So including one in which they were trying to claim paternity. It's not in this case, in this chapter, it's in the next chapter, in which they're trying to claim paternity, and paternity is a very hard thing to find in the 1920s countryside. And the court decided, based on the features of the baby, that it must have matched this man. So he ended up having to pay child support for this unwed mother. At the same time, Most of the judges of the people's courts and all the judges of the revolutionary tribunals were men. And they remained that way through the end of the 1920s, even though they tried to get women on the bench. The one place that women did actually fill roles on the bench were these lay magistrates. They replaced juries, and they were supposed to be allies of the Soviet state that would breathe proletarian consciousness into the courts and remind the judge how to resolve cases in a proletarian manner. So they were often women, often workers or peasants, and yet they remained silent totems. I've never found any examples of the lay magistrates actually speaking a word. Wow. So that way, from behind the bench, women were actually silenced. On the front, they provided an opportunity to seek redress and seek claims.
So how progressive were the Soviet courts in relations to other courts around the world at the same time?
Good question. That's a very good question. I wish I had a good answer for that. So I came up to this topic having looked at how the subaltern used the court system in places like India and Mexico, and that they were able to use the court system, and subalterns were able to use the court system to have a voice. And you see the same thing there. But that is that courtrooms were arenas for those without power to actually have, to use the law for their own good. Because of the nature of the Soviet state and the progressive value, the progressiveness of the Soviet legal system, I would say then that during the revolution they were actually much more progressive than, say, the United States or even in Europe, giving women an equal voice and having a more sort of welfare state. So that's maybe. Yeah.
You talk about you talk about counter-revolutionary issues. How was that defined? Obviously, it's a brand new thing. On the other hand, it must have been under the czars. You could be tried for sedition of some sort, treason or whatever. But this is now a whole social thing, so they're bending it out of whole cloth.
And that was it. When the revolutionary tribunals were established in November of 1917, their scope was actually rather limited, and they were the most active in Moscow and Petrograd. And they really work on these proletarian courts, trying criminals and supposedly trying people who had dirt under their fingernails, or who didn't have dirt under their fingernails, who seemed not to be proletarian. But then in early 1918, they expanded the scope, the jurisdiction of revolutionary tribunals, and what was counter-revolutionary changed, and it was ill-defined because there was no legal code. I've seen kind of schematics where they tried to subdivide what was counter-revolutionary into different political acts. But even then, what I found is that the revolutionary tribunals would come in and prosecute when the state needed it. So when the Red Army took over territory held by the whites, the revolutionary tribunal would act as an arm of the state to establish hegemony. And they would then go after anyone who had served in the White Army or who had been rumored to ally with the Red Army. But then at the same time, whenever there were these drives for conscription, or especially with grain, then the Revolutionary Tribunal would again act as this arm of the state to establish control. And you would see kind of these waves of cases, for example, on grain speculation. So in the spring of 1918, and then again in the spring of 1919, revolutionary tribunals would come in and only try cases on moonshine, or on hoarding of grain, or on speculation, because clearly that's what the Soviet state was worried about. So you see then that it's not so much that the legal code that drives it, but rather the military and political needs of the state. And that once, so yeah.
Well, if you were a peasant, could you figure out what you're supposed to do so that you wouldn't be accused of being counter-revolutionary? You know, like
Yeah,
shoplifting,
that's a
you
good-
sort of know what that is.
So I've been
But-
accused.
So is there a legal code
Yeah.
saying if you do this, you?
I mean, yeah, so there wasn't a legal code, and I've been accused of speaking for the peasants, and I don't want to do that here. But there were, I think, you can clearly see that peasants understood how to use the courts. That they quickly learned the language in the courtroom. So people accused of counter-revolution, or especially as being grain hoarders, used the language of saying that they were old allies of the Soviet state, that they had worked hand in hand with the Bolsheviks. So they understood what we now call speaking Bolshevik. So yeah, so there was an understanding of that, but yeah, there was, I think, a sense of, and this is where the idea of kind of legal order starts breaking down, that if the Revolutionary Tribunal needed to establish control, that it had the authority to do that. You know, Richard Pipes who's a conservative historian of Russia, has kind of the exact opposite idea of me. He called this era that the revolutionary tribunals were established to legalize lawlessness. And I think that goes to too far of an extreme. But it does, in a sense, get the idea that without a legal code, an action that you thought would actually follow in the norms of the revolution might actually be seen as counter-revolutionary. Yeah.
Along these lines, I'm wondering about discretion. How much discretion, what's your sense of that? I mean, kind of developing that commentary, and I was wondering about this earlier on, is how much space did they have to work, the courts have to work to operate, and did they slide back towards Tsarist principles, Tsarist law, you suggested earlier
Yeah.
on? I mean, where would they depend on that, and where would they slip toward proletarian? Is it obvious perhaps, or not?
No, it wasn't, and this would, it would drive the central authorities, the People's Commissariat of Justice, it drove them crazy that the leaders of the Commissariat of Justice were all, from the Tsarist era, they were legal reformers, and they had their ideas of who these judges should be, that they should actually be able to follow procedure well, they should follow the law. And when they slipped back into kind of acting like Tsarist courts, then they would send angry memos, they would send instructions, and then on the other hand, when they were not following procedure, when they were not following especially evidence, the idea of having an evidence-based decision, when judges didn't do that, that also drove them nuts. They would complain often about that these judges were illiterate, that is, if you will, that they were too proletarian, right? That they were following their own wills. So there was this, I guess what I would say is that it's this real slippage in the revolution, that what the revolution actually meant at the center, what the Bolshevik ideas of the courts were, and what was happening at the center, both for the judges and the peasants, were completely different. And then with revolutionary tribunals, there was also some, so they were clearly getting orders from above, but there was also some discretion there. And you can see this, so I followed separate provincial revolutionary tribunals, and some were much more aggressive. And so in Astrakhan, for example, in the south, they executed a lot more people than Vyatka province, for example, in the north. And the central authorities actually came down on them saying you need to stop executing people. And it became by 1919, if a revolutionary tribunal was going to actually execute someone, they had to get authority. They were actually supposed to get authority from Moscow. So there was some slippage here. Part of that is based on the ideas of the court, some was based on institutional problems.
Thank you so much for your talk today. You mentioned that there were a lot of younger judges, and
Yeah.
just looking at your photo that you had up, saw a lot of young faces. So my question is, in regards to this shift as potentially a generational shift,
Yeah.
did that play a role? Was there from pre-revolutionary to post-revolutionary, a huge discrepancy in the age of some of these judges and prosecutors?
Yeah. Do I have it in there in the paper about the age difference? There was the ages declined by about 10 or 15 years, and in the judgeships, in the 1920s. In 1923, a lot of the judges who came to the bench were then kind of pushed out, and they began to replace them with Soviet allies, even younger judges. So there was a shift. If one of the biographies that threads through the book is this guy named Ivan Morozov, and he was, this kind of gives a sense of what you're talking about. He was he had served as a scribe in the Volist administration, in the local administration before the revolution. He then joined the army, came back, joined the party because it was kind of the appropriate thing to do. So he had no legal experience. And then they put him onto the bench because he was an ally of the Soviet state. So he was probably 18 or 19 or something. He was young. And he said that through the 1920s he had no legal experience, and the secretary basically ran the court because the secretary actually understood procedure. He was then trained in these short courses through the 1920s by legal institutions. And then he ended up moving up the ranks. So he went from this local court, and then by the end of the 1920s, he was part of these kind of socially, kind of these class allies of the socialist state, and he would end up joining the provincial, what they called the Supreme Court. Again, still young. And then, if you'd allow me to have a few minutes, he would then be purged under Stalin because he was friends with the wife of someone who was accused of Trotskyism. So he was purged, but that doesn't mean that he was killed. He was actually, he was taken off the Supreme Court bench, and he didn't know what to do. He ended up teaching law, and then during World War II, he was then put back on the Supreme Court. The guy who had purged him, who had led the purges, had the exact same history. He had also been this ally of the Soviet state, exact same age, the guy who kind of accused him. During the war, he would also be taken off the bench and put on the front lines and killed. So there you have kind of these different stories of allies. So yeah, anyway, that's kind of a long answer to your. So yes, they were a different population. It was only, yeah.
If that's like representative of the larger revolutionary
Yeah.
area.
Right.
It's more of a youth movement.
Right.
almost.
Yes, that's right. It was still male. It was only in the 1930s that women began to start. I mean, very few women started to be behind the bench.
Just a couple of small questions about your answer to Brianna's question on gender. So I was thinking about the paternity cases and then also domestic violence cases, maybe sex crime cases, right? Cases where women resort to courts to claim to access some kind of power or to get the courts to take their side in things. You said that, I wanted to think about comparisons under the Tsar and then after. Is there a change in paternity cases?
Yeah.
I would assume there's a change in rhetoric. I would expect it to be at least somewhat religious in tone before, and after it might be different, but then also just in numbers of paternity cases, domestic abuse cases, what's the comparison? And then I wanted to ask about the tribunal picture you showed. There was a couple of women in that
Yes.
tribunal. I just
Yeah.
wanted to know what their roles were. What are they doing?
Yeah, the president was asking.
Sorry.
No, I don't know of any paternity cases under the Tsar's regime.
Huh, interesting.
Because, and that's kind of the whole point, is that the Soviet legal system created a space for women to be able to women usually outside of wedlock were able to claim protection.
Right.
So that they didn't have to rely on customary institutions.
Right.
And some of these claims there was one where it was, this is from 1924, where it was a girl. She was 17. She, the miller, who was rather well off in the village, gave her grain because she was poor, and if her narrative is to believe, she ended up having a kid with him, and they proved paternity because some of her friends saw them together, and 9 months later she had a kid. And so he had to, even though he was an upstanding citizen, he had to pay paternity. So this was that women and the proletariat, that is the poor, were able to use the Soviet state against them. Domestic abuse, so domestic cases of radical domestic abuse before the revolution were handled by the commune, and that if domestic abuse was too abusive, then the husband or the father-in-law could be brought up. There were still very few cases. I can't think of any cases I've read where they actually brought someone up based on domestic abuse, that it was tied to something else. That it was either tied to a crime, an economic crime. When later on, there's a campaign against hooliganism. And there's a lot written about hooliganism, but what I found in the cases, both you can see this in the newspapers and in the trials themselves, that when they were talking about hooliganism, what they were actually talking about was rape and sexual abuse by young men towards women, but they weren't using those terms. So my colleague Sharon Kowalski writes a little bit more about sexual violence, but those are at a higher level of murder.
Right.
Yeah. So the thing about the revolutionary tribunals, if I can figure out how to go back. Oh, there it is. Yeah, I believe they were clerks.
Yeah.
I cannot get names of them.
I mean, now that I look at it, it's like 6 women.
Yeah,
Wow.
yeah, no, it's pretty
Yeah.
remarkable.
Yeah.
They were not judges. The judges were clearly the guy in the black leather,
Yeah.
and here,
Totally.
there.
Totally.
They were couriers or messengers,
Yeah.
and then I
Right.
believe that the women were support staff.
Yeah. Yeah.
Yeah,
And
they're
the
they're nameless.
Totally.
In the archival documents.
Totally. And I guess the
Yeah.
other kind of case that comes up sometimes in court records is bigamy cases. Did you see any bigamy cases? Are people saying, tell my husband that he has to cease and desist this, or cases for impotence cases or infertility cases where wives are saying he's not satisfying his reproductive requirements? Any of that?
I wish, no.
Hey, thank you.
No, because, so when they got divorced, it was, they didn't have to claim a reason. It was no fault divorce.
Right.
There was I also work in Kazakhstan. I work at the Kazakh courts. So in the 1920s and especially in the 1930s, then there's a drive by the state to go after underage marriage to minors, as well as polygamy, and that's where it's kind of different. Those are different cases.
Thank you.
Yes.
Yeah, first of all, I wanted to say excellent talk. I enjoyed it very much, especially the visuals. I do want to ask you, because part of your research did spill over into Kazakhstan.
Yeah.
What were the differences and similarities between law as practiced in the Russian regions, in the core Russian areas, versus in the periphery, in the nationality regions?
So I work on, I looked at the Udmurt Republic and Kazakhstan, the Kazakh SSSR. And first thing is that non-Russians were more reluctant to use the state, to use the court, than Russians. And that's kind of the obvious thing. Even being in Kazakhstan today, you understand how much Russia was/is an imperial force. The archivists love to tell me, one, that speaking Russian was a favor to me rather than speaking Kazakh, and two, that the legal language that I was using was actually not Russian, it was Kazakh. So, but this kind of gets to the point that in the Kazakh regions, what I did was I worked in the one of the oblasts, one of the regional archives, to get a sense of what was going on in the countryside. And the courts were not used that much, that they were turning to traditional courts for family matters. But they turned to the people's courts to handle land and economics. And that the Communist Party kept on trying to get the Kazakhs to use Soviet courts through the 1930s, and they were just failing. So it was clearly seen as a colonial project. I see law and courts as this kind of subaltern school talks about, it's this emissary of the state, and that is kind of a colonial project even in the countryside. But it's clearly in non-Russian regions. I mean, it was consciously this colonial tool. So does that kind of get what you were talking about? Yeah. Yeah.
You were talking about the peasant legal culture, and I was wondering if first you could elaborate on what exactly that was before the revolution, and then how it kind of transformed afterward.
Yeah.
And you also talk about how it wasn't necessarily a full revolution in the way that they used the courts, and yet at the same time you say that there were a bunch of new legal rights that they sued for in the courts, like divorce, paternity, things like that. So could you just elaborate on that?
Yeah. The idea of the peasant legal culture is something relatively new that scholars who have studied the pre-revolutionary township courts, the Volus courts, especially Jane Burbank at New York University, have argued that that peasants quickly adopted to these local courts, that they understood what the laws were, although she says that more importantly that peasants wove these legal institutions into their daily lives. So the alternative interpretation of that is that peasants didn't actually understand the law, that they brought on petty cases, that they filled the courts with nonsense, and the judges didn't know what they were doing. So that's the alternative. She argues against that, and I fully agree with that. That there was this legal culture developed, especially by the late 19th, early 20th century, and some people argue that then ended with the Bolshevik seizure of power, with the abolition of legal codes. But I think you can see this idea that peasants saw the courts as places to seek redress through the 1930s. I don't want to say that they, I used to say that they would seek justice, but I was, someone in a law school said, nobody goes to the court actually thinking that they would actually find justice. Right? But they're actually doing that to seek redress. So I would no longer say that. But that this legal culture of continuing to use the courts or legal institutions or places of mediation to seek redress continued through the 1920s. And beyond that, or through the 1930s, and beyond that, that the officials, even though they're derided by the center, that judges and other clerks and support staff of the courts were in fact knowledgeable, efficient, and handled these cases rather well, despite kind of these claims of red tape and lack of understanding. So that was one thing. The other thing on the developing, what was the second part?
Just more on like how their use of the courts developed through these new rights that the courts.
Yeah, so there was a shift in how the courts, there was a shift in how peasants used the courts, so that they understood that there were other institutions at the local level that they could resolve claims. So for example, there were land committees that often decided land disputes between villages. So that shifted, but there was also a shift in kind of two other ways. One in jurisdiction, that local people's courts actually had a wider jurisdiction than the township courts, including handling criminal cases. So the people's courts heard more criminal cases than before the revolution. But there was also a shift in what peasants came to expect from the courts. Quite early, they understood, especially female peasants, that there were new rights that the Soviet state offered them, family rights, domestic rights, and then later on wage rights that they could use that they didn't have access to before. And that really presents this whole new window of opportunity for peasants. At the same time, it also offered an opportunity for the state to begin to kind of transform these peasants into socialist citizens, into kind of adopting the socialist values and language. So yeah, let me add another thing as well, that this is actually from the Soviet state perspective, is that these courtrooms were much more performative than the township courts before the revolution. That I don't want to call it propaganda, but the idea of using the court system to educate was an integral part, something that Lenin himself talked about, that they need to use the courts to educate the population. And you see this through each of the levels of the court system. So there was a performative aspect of all of this. Yeah?
To pick up on that last point about using the courts as a way of educating the population about what the state was like and what the population's role in that state was like. You mentioned cases where the courts held officials accountable for being overly zealous. I wonder if that was only sort of at the discretion of the state, where the state would sort of pick an official that they thought was overly zealous as an example, or could citizens who had been abused by that official like bring their case?
Yes. Yeah. So I found the latter. By the end of the Civil War, that peasants brought officials, that they complained enough to the state that those officials were brought to the revolutionary tribunals. And this was, but it was discretionary. Right? There were people who got away actually with murder. But this was also a way of establishing hegemony and establishing stability at the end of the Civil War, where they were trying to build more support by the peasants of the Soviet state. I might have said that these officials were corrupt, and nobody was ever brought up on charges of corruption. The idea of bribery and corruption comes after my period. James Heinzen wrote a great book most recently on corruption and bribery, and he talked about this for the later period. But these are, what do they call it? Officials' violations of duty, dereliction of duty. But it comes out to be overzealousness. And it's all over the place. I mean, it is the most, in 1920, 1921, it is the largest crime that the Revolutionary Tribunals hear. That's how important it is. And rightly so. I mean, some of these officials were kind of out of control.
And I was fascinated to see how these revolutionary tribunals that, you know, in the Pipesian view actually were like promoting lawlessness and, you know, promoting terror, actually had a restraining effect that's quite contrary to the sort of conventional wisdom about them. And it's also interesting the extent to which these local officials find themselves, you know, fighting with the checkoff over jurisdiction, over punishment, use of terror, and so forth. You cite at one point the commissar of justice of Saratov province actually criticizing the checkoff. And I wondered if, to what extent you see, you know, parallels with what's going on at the center, because obviously the people at Narkomyust, the Commissariat of Justice in Moscow, they're having their own battles with the checkoff along, I would assume, very similar lines. Do you see a parallel?
Yeah, it's the exact same, and it's the exact same thing, and and they're really going at it as well, where the checkoffs stealing cases, stealing people, and it's also, you can see it as well in prisons where there's a checkoff prisons, and then there are prisons controlled by Narkomyust, and they're stealing prisoners. So it's an issue. I mean, it's really this battle over jurisdiction of justice. So I was at a conference in Russia last year, and a Russian scholar said, no, that's completely wrong. The Revolutionary Tribunals were just arms of the checkoff. All the Revolutionary Tribunal judges were in fact checkists, right? And unless there's something I'm completely missing. I mean, I've looked at this stuff, and they are completely different beasts. And the Revolutionary Tribunal, I mean, Narkomyust clearly says that they are there to put a check on this vigilante justice. James Ryan, my colleague in Wales, makes the same argument. He sees the Soviet state as violent and trying to promote violence, and that there were no limits to this Soviet violence. And I just don't see that. I mean, I really see Narkomyust, that they see themselves as a way of defining what is kind of just violence and what is kind of the just state and the unjust state. There was some cooperation at the local level between the checkoff and the Revolutionary Tribunals at times. You actually see them actually cooperating. But overall, I mean, when things are tense, the Narkomyust really kind of asserts this authority.
You know, what those other scholars may be thinking of are the troiki, the extrajudicial tribunals that the Chekha set up themselves, but those were something that was obviously in tension with the judicial system. This was like extrajudicial sentencing and executions.
Yes.
That the Chekha carried out.
Yeah, and it gets, and those were often published in the newspapers alongside Revolutionary Tribunal cases. So they both kind of have this idea of trying to establish authority. But I mean, I think one's kind of the arm of the beast, and the other one is trying to do justice. Yeah, no, that's a good point. I'll let them. Next time I see Richard Pipes, I'll mention that.
The kind of division that you're describing here, that there's an overarching context. There are two ways to establish a relationship, it seems, between a regime and its population. And one of them, it might be used authority, that is, being able to enforce things. The other is legitimacy.
Yeah.
And I'm wondering if this was perceived at the time, in terms of legitimacy, what people want is a place where they can, one of the main purposes of government is provide places where you can have redress of grievance, where you can adjust conflicts with your neighbor. And for that to be legitimate, it has to be done in a way in which there's not a favoritism that is based on who your neighbor is within a Soviet view, and what class your neighbor is, what gender the person is you're in conflict. And those things, if they're done well, create a rapport between a group, between the governed and the governors on a basis of legitimacy. And then the other alternative is you exert authority, and people support you because they don't dare do anything else. And so I'm wondering whether that is articulated within the conflict between, whether in effect these are, the checkoff and the People's Court are rival ways of establishing the government's authority, whether they know that when they talk about it.
That's a great question. So yeah, there's this concern during the revolution with state authority, or state power was lost in Russian, which is governmentality, and that the court was the legal institutions were one way of establishing authority. And I think you could argue that having authority then gave you legitimacy. That kind of goes against what you're arguing. To answer your question that way, then the revolutionary tribunals would have to also be, so I would say revolutionary tribunals weren't just establishing authority. They were also, because they were supposed to be the proletarian consciousness, that they were also supposed to be extending legitimacy. But in practice, I think what you're saying is that they were established, that kind of this idea that they were actually establishing authority, that they were to be feared, while the people in the courts and other legal institutions were establishing legitimacy. I think that's exactly right. But they're not so black and white, right? Doesn't that kind of, it's a universal, that's a universal part of legal institutions, right? Kind of legitimacy and authority.
Yeah, if you come from a legal background like I do,
Yes.
of course the way you see it.
Yeah. Yeah.
But one is establishing authority through legitimacy, the other one is just establishing authority through coercion. Although the checkoff courts are the coercive.
Yes.
So they'll get legitimacy eventually, but they are establishing authority just by the sheer iron fist. Whereas
Yes.
these courts here are more embedded in local society and
Yes.
embedded chronologically if they're reaching back to czarist, maybe even czarist personnel. That's what I'm wondering about. How many of these people are holdovers, younger members of the older czarist courts, or are those guys completely out?
No, so the czarist courts, at the local level, at the township courts, at the local level, the czarist judges were out, but the support staff remained. At the upper level, actually at the middle level, the regional, the district courts, a lot of those judges remain as well, which is kind of crazy. The Revolutionary Tribunal, these people are all new. These were all these are party officials and veterans. But yeah, at the court level, these were all people who had 75–80% of them had experience from the provisional government of the Tsar's administration. So yeah, there is the thing. But I mean, the Soviet state would still try to make the argument that their legitimacy doesn't come from the Tsarist holdover, that their legitimacy comes from revolution. And this is kind of the problem with, this is why courts and the law play such a complex role with Leninist writings. And he doesn't know what to do with law.
Well, my questions is related to your last comment in some ways. I think of law in the English context, which is, in some ways the American context. context is, it's about contracts in some ways. It's deciding, it's sort of, the complaints for redress are often have a contractual, or documentary, source to begin with, or understanding. And it's about often properties at the heart. It's inheritance, or it's a transaction, or it's, a debt or some other money. Oh, and so I'm thinking of the meta. If you have an ideology that's going to try to eliminate the private property and all these things. I mean, is this why they don't write a legal code in some ways? I mean, when does a code drop, and then does it even contain, what sorts of provisions does the legal code then offer?
Yeah, so the Lenin original ideas was that the courts, obviously the courts were a tool of the capitalist state, and they were all based on property. So with the socialist state, you don't need a law, and you don't need these courts. By 1920 something, he's writing saying, oh well, we're writing a new civil and criminal code. They're having a lot of debates, and it'll come. And it does. By 25, there are civil and criminal codes that are, I mean, some of it goes back to the Tsarist reform. Contract, property, so inheritance, for example, they're supposed to get rid of inheritance, but that is a really hard thing to do especially with land reform. Where does the land go? With divisions in the countryside, there's divisions of property when someone dies, and so the court keeps on saying, well, we can't get rid of inheritance, and the center says, yes, you need to, and they just ignore it. They continue to divide property and settle these property disputes. But you're right that this is not. That it's a different way of looking at law. It's not based on contracts and property.
I would also say that when you talk about the courts being performative, which I think is really, really interesting, the Soviet speak, that people understand there's a language to speak. But I was really intrigued by the photographs of the open air proceedings and the role of the audience and observers.
Yeah.
Because if you don't have a jury system, it just sounds like they were
Right.
toying with it at the end of the Tsarist era, but don't continue on. And jury duty was the way that people participated in government. Honestly, in the early modern era. I mean, if you were unlikely to be an office holder, but you served on a jury, and that was your experience of participation. So I'm wondering to the extent to which this gave people a feeling of participation in the government, in the state, in the ways that you're thinking about legitimacy. In lieu of other forms of participation, did people feel that they were participating in the administration of redress or justice or the state in some ways, even as observers, even as people who attended?
I don't know. I don't have any feedback. The idea of courts as performative in part comes from Elizabeth Wood writes this book about agitational trials that were they were actually performances in plays done in the 1920s of using the courtroom as educational spaces. But you also see this in actual, not in this, but so I don't know about participation. It was really difficult for the Soviet state to get people to agree to be lay magistrates. These were elected positions, and they couldn't get people to come. They couldn't get people to show up. They couldn't get people to actually sign on to be part of these, to actually get onto the ballot. In part because it was unpaid. So it kind of makes me think that they did not want to be part of the court. However, I know that these show trials were actually very popular, but they were popular by design because they would have them during market days. That one was not during market day, but they would have them during a fair or during a market or during a time when the whole village would be there, and they would pick out the juiciest case and one that they knew would, go their way. So, and people attended, and people talked about it. so in that way there was participation, and they were clearly seeing how justice was happening. And then beyond that, let me also say that, and this might be a better way of answering it, that judges were only, being in the courtroom was only a small part of what judges did, which I guess is kind of what happens here. But judges were also supposed to advise citizens during office hours. They were supposed to give lectures across the whole precinct. They were supposed to write articles. They were supposed to answer questions. They would do reading groups, and some of them were really active. There was one guy in Nizhny Novgorod in central Russia that gave, it was like 50 lectures in 30 days. So it's pretty crazy. It's kind of my nightmare as a professor right there. So there was, the whole point of these judges is that they were supposed to be educators, and they were supposed to engage the citizens so they understood their rights and what the Soviet state offered them. So in that way, I mean, it was clearly to bring citizens into the state. And citizens would write in, and they would come to these lectures. So it wasn't just top down, it was clearly this dialogue.
I have many questions, but I will ask three. If that's
Yeah.
all right. So I'm going to start small and get bigger and bigger. So
Okay.
the small question is, can you tell us at all why it is they cared so much about dealing with the cases from before the revolution, particularly dealing with cases that were coming, I mean, a couple of your examples were from very early 20th century, maybe even late 19th century.
Yeah.
I mean, these are things where, these are cases that a lot has happened in between. And why would they make their lives more difficult? I mean, they're overworked dramatically. Why would they do that? I'm curious if you could talk a little bit, so that's the first question. The second one just has to do with the sort of methodologies of how one writes revolutionary legal history. I'm curious about how you approach this as a historian on a kind of methodological level. I mean, how do you approach the sources? How do you analyze the sources? What kinds of, I don't know, are there methodologies you bring to this? And in the sense that there are methodologies for legal history, are there different methodologies for revolutionary legal history or courtroom history and this sort of thing? And so I'm curious about how the sausage is made here. I mean, how do we know what we know, and how are you figuring it out and this sort of thing? And the third question is, so how does this change how we should think about what we say about the Russian Revolution and the early revolutionary years? I mean, I'm curious, how should I change how I give lectures about this? Talking about giving lectures. In what ways does this force us to rethink what we thought we always knew about this revolution or this revolutions? So, yeah, micro to macro.
You can't get bigger than that.
Well, I could, but I'll stop there. I'll save that for dinner.
Why do they care about pre-revolutionary cases? These were, I mean, it's thousands of cases. I mean, they are just overwhelmed that their first year, I mean, 1918 was about getting rid of these cases. I believe that so you can actually see this in decree number 1 on the courts when they abolished the courts. They're also trying to create some, underneath that they're actually trying to create some continuity. I guess it goes back to this idea of legitimacy, that it wasn't a complete break, that there actually is some type of establishment. And I would actually go beyond that and say that this is a way to appeal to citizens to understand that there is some state structure that survives. That's kind of on the larger level. A lot of these jurists, and if you read the minutes of Narkomust, of the Commissariat of Justice in 1918, it's remarkable. I mean, these are just, it's democratic, they're sharing different ideas, they're kind of coming up with this stuff ad hoc, but they're all wedded to the 1864 legal reforms, and which is weird, kind of this liberalism in a socialist environment. So I think for them it makes complete sense that they would continue with these courts, because you don't just abandon legalism, even if the state structure is gone. So of course you have to deal with these cases, and they did. Beyond that, even if they didn't, the peasants would have demanded it. I mean, these were cases that anyone working in peasant history, I'm sure, has seen, where these are petitions that go through generations over claims to a meadow, that villages will continue to petition until something happens. So this is what, I mean, you still see, so yes, so I think that's what's going on. Okay, the methodology, my main methodology is angst. So I read the legal cases as kind of as narratives, and I'm kind of interested in kind of the language behind them. And yet I'm aware in the tensions, I'm always aware of the tensions in studying legal history without being a lawyer. Because I know that there are things in the legal codes that I read one way as a historian that actually means something else. And that's a real challenge. And so I turn often to my legal friends, Peter Solomon, Toronto, who actually understands this stuff, Will Pomerantz. So in that way. However, I would say that as a historian, we're also given tools that they don't have, because they're so, that they see these cases solely through a legal lens. And they don't see, for example, slippages, interpretations that they would see as misinterpretations, but are repeated in case after case, or that they see the law in kind of these liberal views. And so when the state goes against the law, they see that as a problem. Or that is that lawyers often, legal scholars in the Soviet and late imperial impose a value system upon these histories that I do not have. And so I try to work around that. Yeah, so I mean, the main thing is I also try to use some quantitative history. I try to look at these things in bulk. This has been, I mean, I really go back to angst and hand-wringing, but because this is really, I feel like I'm working in sources beyond my expertise, if I can say that, among friends. And as I'm being recorded about this.
It'll be on YouTube.
We can edit it out.
But I mean, I also don't think that's a bad thing. You know, I think it's important to study these cases outside the legal realm. So yeah, that's it. And also, to belabor this thing, I also look at it at a local level that legal historians do not do. I mean, one of the things that I try to get at the personalities and the local ecosystems of these precincts to see how those actually influence the cases. So that's why I'm looking, so the larger project, I have kind of a national view, but I dive deep into Vyatka / Kirov, Nizhny Novgorod, and Samara in particular. And then I also go into Moscow and Kazakhstan. But it's really Moscow, I'm sorry, it's mostly Vyatka and Samara that I'm really able to go down and really understand the intricacies of these courts. And see, that's not just law of courts. So, okay. What does this say about the Russian Revolution? A couple of things. One, that the Soviet state actually it wasn't all about violence, that the state actually mattered, that there actually was a state during the Civil War, that it was much more flexible than we used to believe, that Local institutions matter. And let me also say that having read one of the forthcoming articles in Slavic Review, not David's, but another one, that basically says that we need to understand the Russian Revolution by seeing it as an absence of power. And it's basically the Russian Revolution, it's about the Soviet Union without Soviets, without people. I think showing that people actually interacted with the young Soviet state, that they were willing participants in the creation of the Soviet state, were all really important. So all of that. It wasn't just the First World War, it wasn't just mobilization of the state, that ideas of socialism actually mattered. So there. I don't know if that would actually be in a survey course on Russia, but I think all of those are really important.
So with that, how much, in terms of like education and like, you mentioned how the state came from the people, but also the state kind of tries to educate the public on what their goals were and you know, socialism and things like that. So how did that interplay work? Was it more the state was educating the public and then the public interacted, or was it that way?
Yeah. So education was more top down, and that the values and the ideas came. Although the peasants and the populace could come and ask questions, so there was, in that way, kind of this participatory aspect. But I think that the other thing to remember is that there were tens of thousands of claims upon the young Soviet courtroom, and that peasants were kind of seeking out the legal institution, not just for education, but to be part of this larger state web. I guess that goes back to Nick's question.
Yes, I'm pushing the later chapters, but when you discuss the Civil War on this, at the beginning time, obviously, the whole revolution is faced by essentially an existential threat. And
Yeah.
Who you trust and so forth is a matter of life and death. Once the Civil War is over, things are relatively stabilized. And do you see a real change after that? Then it becomes bureaucratized, and you basically you're not worried about an existential threat, but
Right.
there's plenty of other problems.
Yeah, 1923 is a complete shift in the, kind of 1922, they closed down revolutionary tribunals for the time being. The idea of tribunals would come up again during the war, the Second World War. But the court system completely shifts in 1923. They try to actually train judges in law. They do it poorly, but they try.
They try to co-opt them?
Yes.
They might have been revolutionaries, but nevertheless have skills.
Yeah, and then they also begin to kick judges out of the court and replace them with, by 1923, 1924, there's, judges have to have legal training or experience with the justice system, which, by the way, is if I can say, is the exact same language that the provisional government used in the spring of 1917 to talk about its new justice system. They said that justices of the peace didn't have to be judges, but they had to have legal experience or experience with jurisprudence. Exact same language that the Soviet state then uses in 1923 to talk about its Soviet judges. If you want to see continuity there. So they try to establish effective courts, and the central authorities become obsessed with time to completion. That is, how quickly courts can get through cases. They want it done in 3 weeks or less. The time that the case is actually brought, adjudicated, resolved, and that the person knows or is sentenced, or is put in prison or whatever. And then they just become obsessed with red tape. So by the late 1920s, by 1927, the central authorities have the assumption that most of the judges are ill-equipped to run efficient courtrooms, and that peasants are over litigious. They're an over litigious lot. That they're bringing claims before the cases that they should be resolving elsewhere. So the problem isn't with the Soviet state. The Soviet state believes it's with local administration and peasants. Same language that they used in the late imperial period. So they try to bring in mediation centers that will handle a lot of these cases. And that's done just about the same time as as collectivization. And there's a whole upturning of the court system in the early 30s. So there's kind of a short history. That's chapter 3, 4.
Any other questions? If not, please give